Unfortunately, many employers are finding themselves in the position of needing to reduce the number of employees within the organization. We therefore are working with many employers on how to achieve that necessary but unfortunate goal. We often get asked the question, is it permissible to ask employees to volunteer for a layoff? And the answer is absolutely. It will not always meet the organization's needs to proceed in that manner, but in those circumstances where a voluntary layoff would achieve the necessary personnel savings or staff reduction that the employer needs, it's fine to ask people to volunteer for layoff. There is a provision in the unemployment insurance law that would allow those folks to continue to be eligible for unemployment insurance, even though they volunteered for a layoff. There are certain requirements that need to be met, including that this be a layoff plan that is in writing. So do reach out for help if you find yourself in that situation. Similarly, many employers are considering early retirement incentives. And we often get asked the question, is it permissible to offer an early retirement incentive? And again, the answer is yes, absolutely. Early retirement incentives need to be done carefully. They need to be structured in an appropriate way. And the structure of those plans needs to meet certain guidelines. I do encourage you to work with your attorney on framing an early retirement incentive, because that is a more complex undertaking and can be done wrong. So you need to do those incentives in the right way. Finally, when the voluntary incentives or requests for volunteers for layoff are insufficient to meet the reduction needs, an organization may find itself considering involuntary layoffs or downsizings or reorganizing the workplace, which will involve staff reductions. These are, again, perfectly permissible to do as long as they are done in the right way. You will want to work with an attorney in planning a downsizing, and there are several legal requirements that need to be met, and there are several points of vulnerability that you will want to make sure that your employment action does not fall into. Additionally, advanced planning is very important. Depending on the nature of the downsizing or reorganization that an organization may undertake, there may be an obligation to provide advance notice under what are known as WARN statutes. WARN is the acronym. They're both state statutes. Many states have WARN statutes, and there is a federal WARN statute as well. These are very complex statutes. They're not intuitive. They're not easy to apply. There's a lot of employee counting that needs to be done in a very certain way. There are also exceptions to those statutes. So when emergency circumstances arise that an employer could not reasonably have anticipated the need to downsize, there could be exceptions. So that is another area where it's absolutely imperative to speak to an attorney before proceeding. And then finally, in many downsizing situations, employers will want to offer severance agreements to assist employees to transition to unemployment, to transition to hopefully other work situations. Please have your severance agreements reviewed by an attorney, even if it's a severance agreement that you've used within the last couple of years. There have been statutory developments, particularly in New York, that may require revision of some of those provisions. The other thing to bear in mind is that when you are doing a group termination, which is defined as 2 or more, there are additional requirements that need to be met under the Older Worker Benefit Protection Act in order to ensure a valid release of age claims. So all good reasons and really imperative reasons to speak to an attorney before proceeding with a downsizing or any form of restructuring.